Okay, talk about a little more about literature, science, and junk science. And again, my focus is going to be primarily obstetrics, where I suggest we find a lot of junk science, but I'm going to talk about other areas too. This is by no means confined to obstetrics. But what got me on this obsession with the quality of some medical literature is in 2003, the leading organization that sets guidelines for obstetrics in the United States, the American College of Obstetricians and Gynecologists, published a book dealing with whether or not or how you can relate complications during labor to bad newborn outcomes, to neonatal injury. So ACOG has published this guideline. I call it the Green Book. Some people call it the Meconium Book. But so the Green Book was published in 2003, and it set out certain criteria that I'm going to go over about how you connect complications during labor to bad outcomes. And I remember I had a case in 2004, and I went to my neonatology expert, and he said, you can't win the case because of this new guideline from ACOG that says you don't meet the criteria for causation. You can't prove a link between bad obstetrical care during labor and the outcome. And I said, how could that be? He said he doesn't believe it's a reliable publication. And I read the publication, and I didn't believe it was a reliable publication, but it was issued by a very reputable organization. And so I went to my client, and I said to my client, I reported what the neonatologist said, and I said, let's put the file in a drawer for 5 years, because I don't believe it. Let's put it in a drawer. I'm going to put it in my cabinet for 5 years, and then I'm going to call you in 5 years, and we're going to reopen the case in 5 years' time. We put it away, and 5 years later, we reopened the case, and there was some new data out of Scandinavia that demonstrated that the causation criteria in the ACOG guideline wasn't reliable. We reopened the case and settled for $12.5 million. Okay? $12.5 million bucks. So I'm going to go over that. I'm going to talk about some medical myths in the field of obstetrics. I may go beyond obstetrics. But I think that the important thing to think about is that I think medical literature plays a very important role in everything that your experts do in these cases. You must have medical literature to back up what you do on both liability issues of standard of care and causation. And some of you may have attended my talk on causation. I won't go too far on causation, but last year I talked about causation. But causation asks a counterfactual question. It asks, had the negligence not occurred, would the bad outcome have been avoided? So that runs counter to the facts. If we change what occurred, do we change the outcome? It's a hypothetical world that we operate in when we talk about causation. It asks about what would have happened even though it didn't happen. I also like to talk a little bit about the role that experts play in medical malpractice cases and something called the opinion evidence rule. And the opinion evidence rule is, I think, a poorly understood rule. It suggests that witnesses are not permitted to give opinions. That's simply not the case. The rule is not designed to prevent witnesses from giving opinions. The rule is designed to prevent strangers from giving opinions. That is, people who have no direct knowledge of what happened in the case. So the only way that a stranger to the facts gets to testify in a case is if the stranger has something to offer to the judge or jury that might help the judge or jury come to a sensible solution. Medical malpractice cases, those are scientific issues. In car cases, it may be engineering issues. So the issue is, can the stranger to the litigation, this hired gun, help the judge and the jury understand matters that are beyond their training in order to reach a fair verdict in the case. And the opinion evidence rule then allows an exception by saying, yes, we will hear from that stranger because that stranger can help the trier of fact in rendering a just verdict. And it is from that our rules about unbiased, balanced evidence from experts come from. This is not something that was created in the rules of civil procedure. This is something that exists from the very foundation of the opinion evidence rule. So it's a helping function for matters beyond the understanding of the trier of fact. That's the opinion evidence rule. I say poorly understood. Okay, the other thing that experts need to understand is there is a difference between a scientific burden of proof and a legal burden of proof. I already talked about the 95% confidence interval that scientists like, but at law we only need more than 50%. Now, the burden of proof, and this is a very, very important distinction that we all need to understand. The burden of proof is a balance of probabilities, as I've said. But there is something distinct from the burden of proof, and that is the threshold of proof. The threshold of proof is something less than 50%. When I talk about the threshold of proof, I'm asking this question. How much positive evidence do I need from a witness in order to permit the judge or jury to make a link between cause and effect? How much evidence do I need? And the most important and leading case on this issue is a case out of the Supreme Court of Canada called Snell and Farrell. It's a case from 1990, decision of Justice Sapinka. And it tells us that you can have very little positive evidence. It has to be something more than insignificant or something more than de minimis. But you can have very little positive evidence that will allow the trier of fact to make this causal link. That's important for us as lawyers to make sure our witnesses, our medical witnesses, understand that the burden of proof is something less than, or that the threshold of proof is something less than they're used to in their practice. And again, I emphasize the importance of inference. It is open to a judge or jury to infer from the totality of the evidence a link between harm and negligence. Okay, so as I've said earlier, when I look at literature in these cases, I read all of the literature before I meet with my expert. I formulate a theory about standard of care and causation, which may or may not be borne out by my expert. My expert may come out with additional stuff. But the other thing I'm looking for, not just for stuff that will support my theory, is stuff that might contradict my theory, and how am I going to meet literature that contradicts my theory of either standard of care or causation. And then finally on this point, I want to make sure that any expert that I've retained has considered both the literature for and against my theory and has dealt with it in a way that ensures that my case is not going to be vulnerable down the road to the careful review of experts retained on the defense side of the case. So I'm going to talk about junk science, and I hope I have enough time to, I'm going to talk about some myths about science. But we have to understand what is junk science, or junk is maybe extreme, what is reliable science, or what science is not reliable. And some define it as evidence out of the mainstream scientific thought. I ask, is that a good definition? Because maybe mainstream scientific thought itself is junk. I think of the ACOG 2003 guideline. I think it's junk. Now, I will tell you, and I'm going to talk about it in a minute, that in 2014, ACOG issued a new meconium book, okay, in 2014, and they changed their view on causation in the new book. I'm also going to tell you about the fact that the Canadian version of ACOG, the SOGC, the Society of Obstetricians and Gynecologists of Canada, have really not yet adopted the change that ACOG made in 2014. In other words, SOGC in Canada is operating on the old thought, the stuff that I say is junk, okay? And I'll explain why that's junk. So I'm not prepared to accept that just because something is part of mainstream scientific thought that it's necessarily good science. Some people say that if you have a randomized control trial, that's the strongest form of medical evidence that you can get. Maybe, maybe not. Junk science is also defined as science that is not generally accepted by the scientific community. Is that a good definition? There might be thought leaders in science who may have a different view about these things, and things change all the time. There have been randomized controlled trials that have been proven wrong, that govern treatment and thought about medical issues that have been proven wrong. In fact, just this week, there was a publication in the American Journal of Obstetrics and Gynecology that spoke about this very fact, that sometimes you can't even rely on randomized controlled trials as good guides to treatment or understanding of the science. Junk science is also defined as science lacking the indicia of reliability. But what is the indicia of reliability? I'm going to demonstrate that the 2003 ACOG guideline purported to have indicia of reliability, but really didn't. So can mainstream and generally accepted science lack the indicia of reliability? I say yes, it can. And it's part of our function, I think, as advocates to identify where that's the case. Now, some of you may say, well, that's why we hire experts. Why are lawyers doing this work? This is why we hire experts. What are you talking about? There was a trial that was done in an obstetrics case where the neonatologist for the plaintiff was cross-examined for 2 days on the 2003 ACOG guideline. So his evidence about causation was challenged. The cross-examining lawyer puts the 2003 guideline to the witness and says, well, Dr. So-and-so, how can you be saying what you're saying when this publication from the most reputable group in the United States in 2003 contradicts what you're saying? By the way, this witness was giving evidence after 2014, after the guidelines had changed. And when reading the transcript, the interesting thing was he had no idea how to answer that question. Well, this is just my view, and I know what ACOG said, but it's not my perspective, and so I disagree. But what he didn't know was it had already been contradicted by their own publication. And very few doctors knew it, that it had already been contradicted. So unless you follow it closely, you would not know these things. And it's a situation where, in that particular case, the plaintiff's lawyer couldn't rely on his own expert to keep up with the medicine. Obviously, the plaintiff's lawyer didn't know the medicine, and the witness was vulnerable to cross-examination on literature that really was not reliable literature. I think it's the function of us as lawyers to make sure that we're up to speed on all this stuff and we know what we're talking about. So I subscribe to these publications and I read what comes out. And I keep up weekly on this sort of thing. Why? Because I think I owe that to my clients. I think it's important. Okay, so peer-reviewed studies are not free from bias. I have a friend who is a cardiologist who frequently reviews the cardiology literature, and he says that garbage gets published all the time in the cardiology literature. And we see that a lot. Even in good studies, it really depends on the spin that you put on the results of the study. And the other thing I like to focus on is these so-called meta-analyses where these groups take these 15, 20, 50 studies and they look at all the studies. The Cochrane Review is the example in obstetrics. They review these studies and they make certain conclusions from these studies that, if you read the studies carefully, are not supported by the studies. So you must look at this stuff carefully and say, is it true? I was asked, how do I know whether literature is valid or not? Well, I approach everything with a high degree of skepticism. And where it doesn't make sense, I dig deeper. I may be persuaded that it's right. I may not be persuaded that it's right, but I dig deeper because I want to know what it's right. Remember how much is at stake in these cases. Obstetrical asphyxia cases, they're the largest personal injury cases in Canada. There's so much at stake for the parents that we can't leave any stone unturned in these cases. And that's why I like to think that I'm that meticulous in looking at this stuff to make sure that, if I'm going to turn down a case, I want to turn it down for good reason. And if I'm going to run with the case, I want to make sure that I run with the case for good reason. So in the Cochrane studies, they look at the rates of cerebral palsy. They look at the effectiveness of electronic fetal monitoring. I'm going to talk about that in a minute. And I would say to you, approach all of those studies with great caution. They are seriously flawed. Then there's real-life observations and randomized controlled studies. And some scientists will tell you, well, observational studies are less reliable than randomized controlled trials and therefore cannot be relied on as much to govern clinical care. That isn't necessarily so. And an obstetrician in the United States, a guy by the name of Anthony Vinceleos, has written about that. His article is in 2009, but he's written more than one article about that, talking about these conflicts in the RCTs and real life. And in particular, he says that obstetrics is notorious for these conflicts, and it is notorious. Now, why might that be? Why do you think obstetrics would be so notorious for these conflicts compared to anesthesia or emergency medicine or oncology or something else? And the answer is, it has nothing to do with Canada. The answer has to do with the United States. In the United States, there are thousands and thousands and thousands of lawsuits a year, tens of thousands, hundreds of thousands of lawsuits a year in medical malpractice. And so it's a big problem, particularly in obstetrics. And it's hard, premiums are expensive for obstetricians in the United States. It's hard to get obstetricians. How many lawsuits are there a year in Canada, in the entire country? Anybody know? 1,000, 900, nothing. Very few. How many birth trauma cases are pursued a year in Canada? I'm guessing 25 in the country, 30. We do not have a litigation problem in Canada. What are premiums for physicians in Canada? Peanuts. It's partially funded by the healthcare system. They do not face huge premiums. Doctors in Canada don't have insurance. They're all protected by the Canadian Medical Protective Association. They have unlimited protection against liability, whereas doctors in the United States, if they're not at an institution, they will have limits like people have on their car policy, and their personal assets are exposed in the event that there's a judgment over their insurance limits. Much more incentive in the United States to come up with junk science than there is in Canada, but Canada follows the lead. Okay, so flaws that flow from studies. Studies, even randomized controlled trials, can be biased. When we talk about power, we're talking about how many people are studied and whether you can draw conclusions from the cohort that is studied. There are studies where the design is flawed. So I'm thinking of a study that was done a long time ago on the reliability of electronic fetal monitoring for predicting bad outcomes for babies. And the study design is fatally flawed. It concluded that electronic fetal monitoring, which measures the baby's heart rate during labor and tells you something about fetal oxygenation, that it is not reliable for predicting impaired oxygenation of the fetus in utero. It is not reliable because they had a bunch of doctors look at fetal heart tracings, and they all came to different conclusions about what they saw on the tracing. Now, the study is old, but they only looked at small excerpts of tracing. And there was no other clinical data that they were provided with. The condition of the fetus in labor is not only a function of what the fetal heart tracing shows. It's a function of the uterine activity. It's a function of gestational age. It's a function of duration of rupture of membranes. It's a function of whether mom has fever. it's a function of whether the baby's big or small or malpositioned. You can't look at a fetal heart tracing on its own in isolation and tell anything about the baby without the bigger clinical picture. So this study that suggests that EFM, that electronic fetal monitoring, is not a reliable way to interpret fetal data because there is this what they called inter-observer variability, that is two different doctors looking at the same tracing and coming to different conclusions. And they even found intra-observer variability where the same doctor looked at the strip, again separated by a couple of weeks, and came to different conclusions both times. These are not reliable studies. These don't tell us anything about the reliability of electronic fetal monitoring. So I think that's a big problem. Okay, epidemiology is also something I like to talk about. And again, this is not just obstetrics, this is every kind of medical case. Remember that epidemiology, if you are going to use epidemiology, which is the study of health-related issues in large groups, in large heterogeneous groups who you may have age discrepancies from age 10 to 80. You may have people with comorbid problems and people without comorbid problems. Does it apply to your case? You must look at these critically. What conclusions can be drawn from epidemiology, or what is called evidence-based medicine? What conclusions can you draw? You must be cautious about what conclusions you draw. And they're averages. It may not be your case. They are averages. So you have to also, because of the variables that the cohort exhibits, you must tease out the variables that apply to your client and find out, well, are you average? Are you above average? Are you below average? There's a spectrum of outcomes, and you have to find out where you fit in the spectrum of outcomes. So be careful about epidemiology and general conclusions. All right, so I want to deal with some what I call myths. Again, focus primarily on obstetrics because of its importance. How do you show that interpartum events cause newborn neurologic injury? So the question asks, how do you know whether mismanagement of labor and delivery resulted in a brain-damaged baby? And here's where I talk about ACOG 2003, the meconium book. And they provided in that book 4 essential criteria. What they said is that all 4 of these must be present, or you cannot connect labor complications with injury. They all 4 must be present. So number 1, evidence of a metabolic acidosis in cord blood. Okay, pH of less than 7 and a base deficit of greater than 12. So what happens? Baby's born. After the baby's born, they clamp the umbilical cord. Then they take a blood sample from one of the 2 umbilical arteries, and they take a second sample from the single umbilical vein, and they analyze it for gases, oxygen, carbon dioxide. Because the cord is clamped right after the baby is born, it's a reflection of the baby's blood gas status at the time of birth. So it's supposed to be a reflection of how well oxygenated the baby was at the time of birth. And if cord blood is acidotic, the pH is less than 7, if it's acidotic, it tells you that normal respiration in utero was interrupted, that the baby was not receiving sufficient oxygen, and that the baby converted to anaerobic respiration and created lactic acid and carbon dioxide too high. And then the base deficit of 12 is a calculated value. It's not that important, but it's a calculated value based on pH and carbon dioxide. And there's a graph how you calculate base deficit. So ACOG said in 2003 that unless the baby's cord pH is less than 7, and usually arterial cord pH less than 7, and the base deficit 12 or greater, you cannot make a connection between birth trouble and bad outcome. That's what they said. Now, incidentally, SOGC shortly after this was published, and by the way, SOGC participated in this. SOGC, shortly after this publication, published their own article of causation. And what they said was they agreed with the pH of 7.0, but they added, unless the base deficit is greater than 16, you can't make the connection. Remember, this is essential criteria. So in the United States it's 12, but in Canada it's 16. So what does that mean? It means that babies in the United States get injured sooner than babies in Canada. How does that make sense, right? How stupid is that? Okay, so that's SOGC. And SOGC hasn't even changed that guideline. That isn't true. And there are a lot of circumstances where the cord gases may not be acidotic, but the baby be injured during birth. This is what we must understand. One is, if you had a sudden event, if the cord was suddenly crimped, you had a knot in the cord, or you had a cord prolapse where the cord drops out before the baby does and it gets squeezed. In those circumstances, there's no time for the gases in the cord to change, but the baby's still compromised during labor and delivery, so simply not true. Early onset of severe or moderate neonatal encephalopathy. So neonatal encephalopathy simply means brain sickness, all right? That's all that means. So you have to have some sort of evidence early on of brain sickness. This is the only criteria that is probably true. You do need the baby to be depressed in some way at the time of delivery in order for there to be a connection between bad labor and delivery management and injury. Cerebral palsy of the spastic, quadriplegic, or dyskinetic type. Remember, mandatory. You must have CP of this type if you're going to make the connection. Fiction. Fiction. Not true. Remember the case I told you about that I put in the drawer for 5 years? That kid did not have cerebral palsy. That kid had behavioral problems. That kid had developmental problems, but the kid had no motor dysfunction. The Scandinavian studies that I spoke about, they established that you can have neurodevelopmental problems, cognitive problems, and behavioral problems from birth asphyxia without motor dysfunction. I'm going to talk about 2014 where that's recognized. So that's not true. And by the way, I wrote a critique of this probably in 2006 or 2007. I presented at a conference where they would not publish my paper because they thought my paper was too controversial. And in my paper, I pointed out that all of the footnotes, and there's thousands of footnotes in this publication, which I looked at, all of the footnotes to support the assertion that you must have spastic quadriplegic cerebral palsy, every article that they cited in support of that proposition were studies that looked at kids only with spastic quadriplegic cerebral palsy. They didn't look at other outcomes. It's the only outcome they looked at. So it couldn't possibly have been wrong. And I spoke to one of the leaders of the group that eventually redid this publication. I asked, why don't you withdraw this publication pending your review of it? Because this is being used by defense experts in a lot of cases to deprive kids of remedies. And it's just not right. If you know the publication is wrong and you know that it's being relied on in courtrooms, why don't you withdraw it? Well, she said, I'm only one voice. I can't, not my choice. Exclusion of other etiologies, that's the other one that is true. So every time that we look at one of these cases, the issue is a differential diagnosis. In other words, taking a look at this kid, what are the possible explanations for what happened and which is more likely? And in most of these cases, you'd find that intrapartum events are more likely. So then they changed it in 2014. ACOG then issues this new green book in 2014. And this is what they said. These criteria were useful in clarifying previous uncertainties. There was no uncertainty about CP at the time. The goal of the new report was to review these criteria and their usefulness in light of new knowledge gained since the publication of that report. Nonsense. That's just not right. I mean, you can't excuse what they did in 2003. Advances in neuroimaging can inform determination of etiology and time window. Well, that's true, but that was known in 2003 as well. So remember I said the most important thing when you're looking at one of these cases is to look at the lesions on the baby's brain, because it tells you when the injury occurred and how the injury occurred. That is the most important criteria in all of these cases. When babies suffer asphyxial injury, there is a characteristic injury to the brain that is unlike any other injury. So if you have a prolonged partial interruption of oxygenation during labor and delivery, it results in fetal hypotension, decreased fetal blood pressure. And if you have decreased fetal blood pressure, perfusion to the brain globally is diminished. And because it's a global diminishing of pressure to the brain, you get a bilateral injury, both sides in the watershed regions of the brain. Okay, so that's the injury that you get. If you have a sudden crimping of the cord, so that blood supply to the brain is cut off completely, there is a classic injury that you get. It is to the basal ganglia and thalami of the brain, to the deep gray matter of the brain. And sometimes you get both, a mixed pattern, which means a particularly prolonged injury. The other thing is, the time course of these injuries is well established. If you do a head ultrasound on a baby on day 1 of life, and you find no changes, and you do an MRI on day 3 of life, and you find changes, white matter involvement, gray matter involvement, narrowed ventricles, evidence of cerebral edema, it proves that the injury occurred in the last 7 days or less. Unequivocally, it proves in the last 7 days or less. Once you do that, the question you must ask is, what happened in the previous 7 days that would explain this injury? And inevitably, in a healthy pregnancy, term baby, inevitably the answer is, you screwed up labor and delivery, right? You gave this mother too much oxytocin. You didn't respond to the fetal heart rate tracing. That's what happens in these cases. We pose the following question. What is the purpose of identifying an acute interpartum hypoxic ischemic event as a contributory fact to neonatal encephalopathy? Well, that's a good question. One is, does it guide treatment? Does it mean that nurses, doctors, midwives, and others aren't using EFM properly? Does it help the family? Does it improve clinical practice? But one of the answers that's really conspicuously absent from here is, what about accountability for what happened? Where does accountability fall? You need to be accountable for what you do. We're not going to be able to change practice unless people are accountable for what they do. Okay. Then SOGC publishes a new guideline in 2020. I think my critique of this guideline is probably on our website if you want to see it. It's on our website? Yeah. So I did a lengthy critique of this guideline, which you'll find on our website. How do you show that interpartum events cause newborn neurologic injury? There were, under the old ACOG 2003 guideline, I showed you 4 essential criteria. There were a whole bunch of non-essential criteria, but things that it makes it more likely that there's going to be an injury that's related to labor and delivery, and these are some of those criteria: APGAR scores, seizures, multi-organ dysfunction. So multi-organ dysfunction would involve kidney dysfunction. These are transient, though usually kidney dysfunction, liver dysfunction, gut issues, heart issues. Some hematological dysfunction, I think, is a little controversial. But in 2003, ACOG said these aren't essential. They're just more clinical factors that suggest that there's a connection. In 2020, SOGC says you'd expect all of these things to be present if interpartum problems caused injury. Not true. Not true. So that's SOGC, that's Canada. Then they continue to perpetuate this myth about a severe metabolic acidosis, SOGC, pH less than 7. Now they're saying a base excess or base deficit, the same thing, 12 or higher. And in the 2014 ACOG version, They no longer stick with this 7.0 threshold pH. They've changed it. Well, it could be 7.1. Some literature says 7.2. And they don't say it's an absolute deal breaker. They say it makes it more or less likely that if the pH is higher, it makes it less likely that there's a connection between birth events and the outcome. I don't know how much time I have. But, okay. All right. So, and then the other prominent thing, which I find so objectionable about SOGC, is that they make no mention of the importance of neuroimaging in making this diagnosis. And they don't mention the importance of the differential diagnosis, which is probably the most important thing. When I talk about the differential diagnosis, what I mean is if neuroimaging establishes what I'll call a peripartum injury, so something occurring around the time of birth, but not with the precision that we need to know, then we need to apply the differential diagnosis, see what happened in that interval that might explain that injury. They omit a differential diagnosis, which is so critically important to knowing what happened. Okay, so this is not the myth, this is the truth, according to you-know-who. How do you show that interpartum events cause neurologic injury? Number one, it starts with neuroimaging. Number two, what happened within the window of opportunity? You like that, Diane? What happened within that window of opportunity? What is the mechanism? Remember, if it's a hypotensive mechanism, you have to have reduced cardiac output to explain the hypotension. That's why there is less blood supplied to the brain. So what is the mechanism? What's the differential diagnosis? Was mom traumatized? Was it a genetic cause? Was she bleeding? Did she have preeclampsia? Was she hypertensive? Did she have diabetes? All these things you have to think about. What's in the differential? And then what do you do with these outlying variables that ACOG talked about? APGAR scores, cord gases, non-motor dysfunction. And the answer is that they're factors, but they're not deal breakers. So if you have a good APGAR, it doesn't mean that the baby wasn't asphyxiated. If you have good cord gases, it doesn't mean that the baby wasn't asphyxiated. It means you may look to other places for an explanation, but in the absence of a better one than birth asphyxia, you must land on birth asphyxia. Here's one that has bothered me for a while. The active phase of the first stage of labor begins at 6 centimeters. So this is also, I think, a US-generated problem. What's the importance? What is active labor? Active labor is when the uterus is contracting regularly, and then during the first stage of labor. So previously defined as when mom reaches 4 centimeters of cervical dilatation is the onset of active labor, up until full dilatation at 10 centimeters. Now, why is this important? It's important because once mom gets into active labor, you expect the cervix to dilate at a certain rate, about 1.2 centimeters an hour. Okay, so if she's contracting regularly, you expect her to dilate at a certain rate. What happens if the cervix is not dilating at that expected rate? Well, it's dangerous for the baby because labor is not progressing as you expect. The baby is stressed by contractions. The baby is exposed to more contractions. Contractions squeeze the blood vessels in the placenta and the uterus, intermittently interrupt oxygen to the baby, and it could be a problem the longer this goes on. And why is the baby not progressing through the birth canal? Well, there's one of 3 explanations, what they call the 3 Ps. Power, are the uterine contractions strong enough? That's power. Passenger, is the baby too big to be delivered, or is the baby malpositioned? Sometimes the baby's head is tilted. Sometimes the baby, ideally you want the baby looking at the floor if the mother's on her back. If the baby's looking to the side or to the ceiling, it's not so good. All right? Or passage. Is the mother's pelvis too small for the baby to pass through? Now these are 3 very different things. If it's passenger or passage, no amount of labor is going to get that baby through that pelvis. It's just not going to happen. So if you continue to up the oxytocin in an attempt to increase mother's contractions, you're just going to stress the baby more. You need to determine what that is. So why is this important? Because doctors in the United States were being sued for allowing first stage labor to go too long. Because from 4 centimeters to 10 centimeters. But if we shorten the active phase from 6 centimeters to 10 centimeters, we can excuse the delay in progress between 4 centimeters and 6. You follow me? We don't have to worry about between 4 and 6. We only have to worry, so between 4 and 6 centimeters, you can dilate it 1 centimeter every 5 hours, nobody cares. It's between 6 and 10 that matters, and therefore, doctors were being allowed or excused from intervening because the rate of change was measured only from 6 to 10 centimeters instead of 4 to 10 centimeters, and that helped them in their lawsuits. Well, the fact is that this was based on a study that has since, I think, been established to be incorrect and not reliable. And the answer isn't, it's nuanced, right? Obstetrics is an art. The answer isn't that absolutely active labor starts at 4 centimeters or 5 centimeters or 6 centimeters. It depends on the clinical circumstances. Is mother contracting regularly at 4 centimeters? If she is, then she's in active labor. If she's not, maybe she didn't start active labor till 5 centimeters. So there's a lot of clinical judgment that would go into that. Okay, so this is another myth and a dangerous thing, I think, for both maternal and fetal health, right? Because ultimately, these guidelines need to be geared towards preserving maternal and fetal health, not defending lawsuits. That's not what these guidelines are about. EFM does not reduce fetal morbidity or mortality. So there's an attempt out there to diminish the importance of electronic fetal monitoring in assessing fetal well-being in utero. Why? Because all these lawsuits about doctors failing to respond to decelerations in the fetal heart rate. That's why they want to diminish the importance of electronic fetal monitoring. It is known that there is a direct association between fetal heart rate patterns that deviate from normal and HIE, hypoxic ischemic encephalopathy. And Vince Leos, who I've talked about before, says the greatest breakthroughs in obstetrics over the last 3 decades are EFM and ultrasonography. Every obstetrical care provider uses EFM, particularly for at-risk patients. There's no doubt about it that virtually, even those arguing against the value of EFM use it on all their patients. It would be substandard not to do it. And you can't have randomized controlled trials to study the impact of EFM because that would mean depriving some kids of EFM, and you can't do that. It's not ethical to do that. Okay, so so what they say is EFM is flawed because it results in too many false positives. So what do we mean by a false positive? What the detractors of EFM say is that if you see fetal heart changes that don't look normal, and you intervene, and you find a perfectly healthy baby, that's a false positive. In other words, you had a positive bad tracing, but when you intervened, your baby was well. Well, therefore, EFM is no good. Well, just a minute now. What's the purpose of EFM? The purpose of EFM is not to find out a baby so compromised as to be injured. The purpose of EFM is to identify a baby that is at risk of injury and intervening before injury occurs, which means that EFM used properly always results in a false positive. It has to always result in a false positive. If it doesn't result in a false positive, you've used it incorrectly. So it is not an argument against the value of EFM to suggest that false positives are a justification for detracting from its value. That is a fiction. You must not listen to people who say that. There's a recent article published about this that promotes that theory by a guy by the name of Stephen Clark. It's just not the case. So I call this smoke and mirrors. What would happen to those babies if you didn't respond to the EFM? Well, eventually they'd go bump, 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 and fall off the cliff. they decompensate, they would be injured, or they would be dead. Antenatal causes explain the vast majority of cerebral palsy cases. So the obstetrical community would have us believe that only about 7 to 10% of all babies with cerebral palsy suffered cerebral palsy because of errors during labor and delivery, or even not even errors, just because of labor and delivery, with or without errors. But there's literature out there that completely contradicts that, that says that it could be 50, maybe 80% of babies with cerebral palsy have that because of interpartum events. But what I will say to anybody who does this kind of work is, it doesn't matter. It doesn't matter if it's 1%. If 1% of babies can suffer injury because of mismanagement of labor, then that may be your client, right? The fact that you can suffer injury by virtue of a mismanaged labor is enough to get past the threshold of proving causation. It happens, and it happens in absolute numbers and large numbers, very large number of cases. So one of the leading pediatric neurologists, Volpe, in 2012 in an article he wrote, and he published, I think, one of the most important texts, Neurology of the Newborn. I think he's now retired, but he said that from 50 to 80% of neonatal encephalopathy in the neonatal intensive care facilities are considered to have hypoxic ischemic encephalopathy based on clinical EEG and MRI criteria. This is extremely important. 50 to 80% of babies with HIE meet this criteria. Now that is highly significant because that is a contradiction of what the obstetrical community would have us believe. What happens in a lot of our cases, the parents have a bad outcome, a young couple, they go to the doctor and they say, "Doctor, what happened to my baby? Why is my baby injured?" And the response is, 93% of the time, it's from things we just don't know. We don't know why these babies get hurt. We can't explain it. There's a certain number of babies every year, thousands of babies every year, get cerebral palsy from what they used to call idiopathic causes. Now they call cryptogenic causes. It doesn't matter. Unknown causes, act of God, whatever they want to call. We don't know why your baby was hurt. These things happen. Some parents accept it. Some parents come to our office and say, "Can you tell me what happened to my baby?" And I say, "Yes, I can." So that's part of the problem, is that this data is used to suggest that the vast majority of cases of cerebral palsy are due to non-labor related events, and that, I suggest, is also a myth. So there's lots of data. I don't want to eat into Duncan's time, so I'm going to just go over this myth. Enhancing patient safety requires changing the culture of healthcare delivery from one that names and blames to one that is dedicated to reducing medical errors. I say, hold it. What are you talking about, names and blames? You mean accountability? Is that what you mean? Do you mean that you should not be responsible for substandard care? Remember, when we talk about substandard care, we're not talking about a judgment call. We're not talking about something within the realm of acceptable practice. We're talking about unacceptable practice. We're talking about a healthy term newborn for whom the expectation was the baby would be entirely normal, but is rendered injured by virtue of unacceptable labor and delivery care, entirely avoidable injuries. All the cases that we do are injuries that are entirely avoidable. All the children I represent should have been normal with proper care. You mean, if I hold the physicians and the nurses accountable, that's naming and blaming as opposed to accountability? I mean, this is complete nonsense. And you'll see this publication in college publications, in CMPA publications. This is directly from ACOG. So I think we have to get away from that. So I'm going to allow, I know that's highly technical stuff. I think what I was trying to demonstrate is that we have to approach the science with some degree of skepticism. If it knocks our case out, so be it. But let's make sure that we do our work to make sure that we're looking at reliable stuff, and we're giving our clients good advice. Anybody have any questions about an overly technical talk? Yeah, Diane.
Yeah, I noticed that you drew two conclusions to the fact that there was cerebral damage. But this is a group that has dealt with acquired brain injury. We say it's location to determine the outcome. I wonder if it would be any value at discovery to predict the outcome based on the damage, and you would use Charles AI and use your understanding of location as it predicts disability or impairment or outcome. I wonder if it would be of value at discovery to say, we knew that was going to happen. We predicted that was going to happen, that these sets of impairments would happen. And I think it would be very valuable.
Yeah, so the location of the injury on the brain, right. The topography of injury, though, isn't always a predictor of outcome. I mean, neuroradiology alone is not always. So you can have white matter injury as an example, but not have the same disability.
Data you want, if you can predict the outcome.
Yeah.
I wonder if it'd be valuable.
Diane, don't forget that the brain has plasticity, so what you predict today in a young child might change over the years.
Although it's different with cerebral palsy, all right, because cerebral palsy, the injury declares itself within a month or so of injury and never changes. It's static.
The injury itself
Yeah.
is the facts, but the learning, and if that child is
Right.
exposed to the learning, it can compensate.
Right.
And it's
Right.
difficult to explain, but plasticity plays a role in the learning, so
Right.
it becomes a little tricky.
Mm-hmm. Right. Right. Yeah.
How do trial judges respond to your critique or attack on ACOG SOGC guidelines? I imagine they would give a lot of deference to those types of guidelines. And how do you advance the type of arguments that you're talking about here to dispel some of the myths when the trier of fact is often very deferential to the medical community?
Yeah, so that's a great question. And that's why I used the example of the trial where the expert was cross-examined on an ACOG 2003. My view is that you must prepare your experts to meet this and to be prepared to criticize. So, you know, if I'm talking to my expert who's going to testify and I say, you may be confronted with literature in trial during cross-examination, you're going to be asked if it's authoritative. If it's authoritative, then you can be cross-examined on it. If you agree it's authoritative, there's a reason why you're being confronted with the literature. There may be something in there that might contradict your evidence. You have to circle back to what's our theory of the case. If your opinion is valid, and if there's an apparent contradiction with that literature, you must consider that contradiction to be incorrect, otherwise your opinion is incorrect. So if you believe your opinion to be correct, and on its face there's literature that seems or appears to contradict that evidence, you must be prepared to deal with that in the stand and say, hold it. That isn't us because epidemiology, we didn't fit within that cohort. That isn't us because that study was flawed. That isn't us because that study was overruled by the 2014 study. So it's all about why would an apparent contradiction in a piece of literature actually not contradict your expert. But it's part of the briefing of your expert. You as the lawyer can't do it because what you say about the study is meaningless. But you as the advocate must be prepared to confront that with your witnesses and brief them on it, so during trial, your expert doesn't get into the same trouble that this neonatologist got into, where he had no idea how to deal with ACOG 2003, and it would have been easy had they known about it. Really easy. Or ACOG 2003, it's an essential criteria, according to ACOG 2003, that to make the connection, the link, you must have spastic quadriplegic cerebral palsy. Well, Your Honor, says your expert testifying, if you look at the footnotes in ACOG 2003, you will find that the studies they relied on were populated only by kids with cerebral palsy of the dyskinetic quadriplegic type. It did not consider kids with a non-motor dysfunction. But if you look at these Scandinavian studies in 2007 and 2008, you will find that there is actually a connection. So you can't rely on ACOG. Now that's very persuasive stuff, okay? But this is what I'm saying, why it's so important for us as lawyers to know the medicine and to help our witnesses confront contradictions. I mean, if the expert is wrong, that's a whole different ballgame. But I'm hoping that by the time we get to trial, I believe the expert's correct, and my expert believes that he or she is correct too, right? Anybody else?
Sorry, 1 second.
You mentioned that accountability for physicians is a way to introduce changes in the guidelines, right? Also called maybe implementing real-world evidence. But in academia, they don't accept real-world evidence unless it's coming from insurers.
And it's coming from where?
Insurers, obituary, insurance data, they accept. But if you present your case or you write in medical articles, you have to have like right paper criteria for evidence. And RCT, as you said, is the first level ranked evidence. We understand that not all clinical trials can be done with RCT. You said it's unethical to not giving people treatment or method if it works. But on the other hand, if you're the first person to talking about this or you're presenting this evidence, they don't take you serious, you can't be published and you can't introduce this idea. So how to overcome this? What is the role of the lawyer to produce real-world evidence?
Well, so first of all, there is a ton of clinical practice in medicine that is not based on RCTs. A ton of it. Observational studies, and the reason, and it's relied on, and it's accepted practice. It becomes a standard of practice, or causation, and the reason is because you can't test for some of these things, but it's accepted. Let's take causation, for example. These blood gas issues as an example. These studies are animal studies. They didn't test these on humans, but they extrapolate from animal studies to humans. They tested pigs and monkeys and dogs and that kind of stuff, and they extrapolated. So there is a ton of science out there that is not RCTs, that is generally accepted by the scientific community as reliable both for guiding treatment and also for making the causal connection between clinical events and outcomes. And that has to be, because you can't test everything. And then if you want to, again, RCTs are themselves vulnerable to the same limitations as these other studies too, but we don't have time to get into that. Anyway, thanks everybody.